And he was doing that in the discharge of his rights as a registered voter required under Article 257 of the Constitution. And that is the dichotomy that is necessary. That in one aspect, he was discharging his functions under Article 132 of the Constitution. In the other, he was exercising his rights as a registered voter under Article 257, which is entitled to. The important thing is that throughout the submissions that have been made yesterday and some of them today, nobody has said what right there is to limit any of the president's powers under Article 24 of the Constitution. Nobody has justified any limitation on the rights of the president under Article 24 of the Constitution. All my learned friend, Mr. Mutuma, said is the minute you are appointed as president, you lose some rights. What is the legal basis for that conclusion? No law was cited. The second issue that my ladies and my lords I want to comment about is the comment that was made by Mr. Ogada saying, if you want to add constituencies, where are you going to get the landmass? Very interesting question. I was surprised, but interesting question. My lords, in 2010, there were only 210 constituencies. The people of Kenya increased the number by 80. They did not expand Kenya. It was the same landmass, but they were able to increase the number of constituencies. And I dare say that is why both the High Court and the Court of Appeal have not faulted the power of the people to increase the number of constituencies under Article 89 of the Constitution. And so, my lords, I think it is, I just needed to make that comment because it's an important issue to comment about. Lastly, my lord, this issue of constituencies, I have referred you to the documents that we filed on 14th of January. My learned friend has just referred you to it. There is a report by the IEBC. If you look at the conclusions on that report, the concluding pages, I think it's page 38 or 36, you will notice that the people of Kenya in many memorandum asked for increase in the number of constituencies. Now, the interesting thing is that nobody has disputed the fact that these issues of increase of constituencies and so on, the 74 issues that you are referred to, these came from presentations that were made by the people of Kenya through a process established by the president. It's the people of Kenya who gave their views. Nobody has said that it is not the people of Kenya who said it. And the minute the sovereign have given their views, how that views then translates into the process under Article 257 cannot be faulted. Lastly, my lords, I just also needed to comment on what Mr. Lesenku said about the case I referred to, that when I was asked by his lordship, if from research we are aware of any head of government that has been able to undertake popular initiative. And I referred you to the country that I referred to yesterday. And my lords, you will note that that is the system of government that that country has. There is nothing more superior about the system of government that Kenya has over that of that country. And so the fact that he's a prince that is the head of that country does not take away the fact that he is the head of the country and that the people voted and approved a process that he initiated. I thank you very much for your patience and for giving me that opportunity. Thank you.
Once again, Honorable Justice of the Supreme Court, thank you for the opportunity to make our closing argument. You've had a lot of arguments before this court, and no party has raised any serious challenge to my appeal. I therefore ask the court to just looking at that to see that there is general concurrence before the court among the council that the finding of the High Court on the provision for distinct referendum questions is not a highly contested issue. Before I do my closing argument, I wish to acknowledge the Solicitor General Kennedy Ogeto, with whom I worked for about 3.5 years after graduating from the University of Nairobi, for his mentorship, and I thank him for his training to always have a strong work ethic, which I think he always practices. As a man of great work ethic, and I thank him greatly. In terms of a few issues that have arisen in terms of what the parties presented on my appeal, I would like to ask the court to remember one thing, and one thing only, that when it comes to expression of the sovereignty of the people, there's the key tool that they use to express their sovereignty is through voting. And the referendum is one of the most important tools, which does not happen very often. But when it happens, let the people get the opportunity to carry out a referendum that will reflect their will. And as I argued yesterday, when you look at Article 81 of the Constitution, there are very important principles that have been laid down to determine what is considered to be a free and fair election. A referendum is an election. To determine what is to be considered in a referendum as being free and fair, it has to be neutral, it has to be efficient, it has to be accurate. And we cannot talk about accuracy if we lump up all the amendments in one referendum question. The argument by the IEBC that this question is not ripe, that argument is not well founded in law. As I already demonstrated yesterday, Article 22 of the Constitution has limited the application of the political question doctrine in our country. It has given the people access to the court whenever they feel a threat to the Constitution. When I filed my petition E416 of 2020, I did also file a supplementary affidavit dated February 19th, 2021, which you shall find at volume 33 of my record of appeal at page 49 to 4950, and also at volume 34 of my record of appeal, page 4951 to 4971. If you look keenly through my affidavit, I did demonstrate that there was a threat that we could have a referendum anytime if the High Court did not actually make the findings it did when it made its final judgment. I laid down that the IEBC had even prepared a budget for the referendum, and it's very clearly indicated in that affidavit. I ask you to look at it, look at the budgetary estimates for the referendum, all contained in that affidavit. Lastly, in terms of whether this question of multiple referendum questions is actually an alien concept, I would say it is not. It's something very mainstream. Already other courts have declared that, and I'll ask the court to read carefully through our bundle of authorities. I did file 9 volumes of that, and there's a digest as well. There's one of the authorities that will show that in our country already the courts have recognized that even before we came before this court on account of the Amendment Act, the Amendment Bill of 2020. Also, there's the Elections Act, which makes some, though not many provisions, but there's some provisions contained on the conduct of referendum. And when you look at the provisions, our law, our parliamentarians already recognize the need for multiple questions in a referendum. Very finally, Honorable Justices, I just wish to end with a short clarion call to the judges. When we came before the court in 2020, as ordinary citizens, as patriotic citizens of this country, we were seeing that there was an attack on our Constitution, which we consider to be the bridge that connects all of us as a people, our diversity, and even the inequalities that we face. That was the bridge that we built in 2010. And our cry then was that we are seeing an attempt we saw as the Breaking Bridges Initiative. What was going to break the bridge? There are many, many bridges contained in our Constitution to protect and establish our rights. And we cried to the court and said, please build a wall around our Constitution, and build a wall they did. The High Court built a big, beautiful wall, which the Court of Appeal not only accepted as a great mechanism for our Constitution, but went ahead to paint and set up surveillance systems around that wall. All I ask the Supreme Court is that may you find it to be the right thing to do under Article 3 to commission that wall. Thank you.
Thank you very much for those responses. That brings us to the end of the hearing of this case. Did you want to say something?
My lady, the Chief Justice and President of the Supreme Court, my lady, the Deputy Chief Justice, my lady and my lords, I think it will be an abdication of our duty on this side if we didn't make very few remarks as we come to the end of these proceedings, with your permission, my lady. And I just want to thank you, my lady, my other ladies and my lords, for the opportunity that you've given us to argue this very important matter in a very good environment. And I think I speak for all my colleagues in saying that you've conducted these proceedings, my lady, with the utmost professionalism, order, and decorum. I must also acknowledge that on this side, my colleagues have shown exemplary professionalism that really befits appearance before this court, the highest court in the land. You have a heavy burden, my ladies and my lords, as you retire to consider this matter of monumental importance to the people of this country. I know we've had very powerful submissions. In some instances, emotional submissions. But my lady, my other ladies and my lords, we look forward to the fact that you will do justice to the case before you, and that you consider it devoid of any attraction to emotion. And has been indicated by various parties in the course of the hearings, my ladies and my lords, the decision that you will make is one that is going to be with us for posterity.
Thank you very much, Mr. Ogeto. Please don't open the submissions.
I am not repeating the submissions, my lady.
Yes.
Only just to thank you once again. And thank you very much once again. And we hope that the decision that finally comes out of your ladyship's and your lordship's hands will be one that Kenyans will have respect for, and that Kenyans will agree with, and that all of us will agree to be bound with. Thank you very much.
Thank you. I only take the vote of thanks. And also on behalf of my colleagues, the justices of the Supreme Court, the registrar, deputy registrar, and the entire Supreme Court staff who have worked very hard on this particular appeals, we want to thank you also most sincerely for your submissions and for your very, very able representation of the various parties that you have represented here, and also for the material that you have shared with us. You have availed a lot of material, including Dr. Kamilwa, who has donated some books. This will all help us reach a just conclusion of the matter. So we are very, very grateful for this, and we are also grateful for the people of Kenya for giving us this opportunity to serve in these positions. Thank you, and have a very nice afternoon. The court will adjourn. The date of the judgment will be given on notice. Thank you.
I just want to seek a clarification. Yesterday, NTV in the prime time news indicated that the judgment will be delivered on 14th of February. I just want to get clarification from the court that directions are not being given in a manner that we are not aware of. Just a clarification.
I do not know where the Nation NTV got the date of 14th of February. I do not want to enter into that. The decision of the judges is that the judgment will be on notice. You'll be given a notice of when the judgment will be delivered.